Now, an issue, by the way, on just revoking one will and making a new one, it does not mean for a single second that the new will might not be contested, because you may, in a fit of rage, gone and got angry at someone and made a new will to take them out of your will. So just because you do something doesn't mean it's going to hold up under the light of the law. Another way to, in effect, have a revocation is to get married, and then your old wills are automatically null and void, and you have to make a new one. And you could add a codicil, but that's not revoking, that's simply amending maybe one small part, or adding another part to your will. So it's just important to understand what that term means if it does come up. Renunciation is where I have been appointed as your executor. I look at it, and due to my workload and the fact that geographically we're not that close together, or whatever other reason, could be health, could be age, and I say I do not want to do this job as the executor, so I renunciate my position and the fact that you've asked me to do it, but I'm just going to go to court and say I don't want to do it, and then someone else in the family can take over if they're approved by the court, or the court will just appoint someone and they'll go from there. Now, under liabilities, the key issue is that there are a lot of liabilities involved in estate planning. You remember the items before, the legal list, prudent investor, you've got businesses. I mean, there's all kinds of complexity. One child wants something and another doesn't, and who knows that a lot of stuff is just disappearing. So it's quite common to relieve the executor of basic liabilities for things that are kind of beyond their control. That's not unusual. Taxation, big issue, because there's a lot of tax issues that people are not aware of, and that can be very complex, so the executor has to have some knowledge about that. If they don't, they have to bring in someone at an expense to provide that tax knowledge. A term here, if you don't have a will, you have, from the government's point of view, died intestate, which means you don't have a will, and your assets will be divided up according to spouse, children, adopted children, brothers, sisters, and things can get a little bit complex. Different jurisdictions will have a different list of priorities, although they're quite similar. The problem with this is people may end up getting some assets that you would prefer not to, but if you die intestate, well, that you don't have a whole lot of choice. That's the way it is. Charities is, a lot of people leave money to charity, and the advice I would give you about this is be specific of what it is you're doing, how much you're leaving, who exactly it's going to, maybe why, and be sure to put in a priority list of, you take all the assets left in your estate, and let's assume it's all put into cash, and then you're going to do distribution as an example. But don't just start naming who's going to get what if you don't have a priority list, because if you're running out of money, it's not uncommon for charities to fight for what you had put in your will, and that may be to the detriment of other people. Property, obviously you include all forms of property, anything you can possibly think of. If it's not there, people will not know about it. Safety deposit boxes, jewelry, and on and on and on. You may have put beautiful artwork in a museum. Well, if you pass away and nobody knows about it, well, I'm sure that'll make the museum pretty happy. So, just try to be as detailed as you possibly can. You're not going to be perfect. This is just the way life is. You're not going to change your will every time you have a cup of coffee. But the idea is, if you're thinking about all the complexities, you'll have a much more accurate assessment of what you're trying to accomplish. Now, if you're setting up trust funds, obviously it's going to be a testamentary trust. That's done by way of your will. Life estate is covered under power of attorney. If you're disabled, incapacitated, who's going to handle your affairs. There's another term this could refer to where, let's say a husband has $1 million, and what they might do is give their spouse a life estate, which means they would get an income as long as they lived from the interest or the earnings on that money, and then the money would go to the children or the grandchildren, just as an example. But that's the reference, what that term is referring to. The power of attorney, it's a completely separate document unto itself, very complex, very important. Never sign one of these if you don't go and do some study. These are very dangerous documents. It's a necessary thing that a lot of people don't give a lot of thought to. For example, if you're incapacitated and you're not paying your bills and you've destroyed your credit and nobody knows what's going on, important, but more important that you understand the risk involved with power of attorney and who has control and how much are they going to be compensated. Schooling is relatively straightforward. You know, you want your kids to have money to finish school, and there could be trips, books, and all kinds of supplementary issues, but that's the job of the parent who is making the will to identify the schooling goals and have a sense of how much that's going to cost and make sure that the money will be there to handle that. And the issue about children is who's going to look after them, what compensation are the people going to receive, where's the money going to come from, who's going to manage the money, what happens, for example, you die, you have an executor, your kids go to your sister, and so everything seems okay, but then the executor dies. Now who takes over from there? So you can see that you're not going to have a perfect scenario, but if you're always thinking and always planning, you'll have a much better chance to handle things that do show up. It's kind of like the, what do they call that, Murphy's Law? Anything that can go wrong probably will, so try and plan for it. The term right here, settlor and the grantor, is the one that actually makes the will, and of course they're putting their assets there, and they're going to ask their executor to take care of the distribution and all the other factors that relate to their estate. There's a term here, per stirps and per capita, that may show up, kind of a legalese term. And it kind of relates to tenants in common and joint tenants. And let's look at it this way. You have a cottage and you have 3 people involved in the cottage. So you and 2 friends each have 1/3 ownership. If you die, what happens to your share of the cottage? Now if you want it to go to your family, what would you do? You would have it on a per stirp, so it will go down your family line. Then if your family dies, your one child, then it will go to, say, another brother or a sister. But the idea is it stays on your side of the family. Now you may have a life insurance component with the other 2 members of the cottage to, if you were going to have a case where you had per capita would mean that 1, 2, and 3, number 1 dies, number 1 share goes to 2 and 3, so 2 and 3 now have 50% ownership of the cottage. But there you would have a life insurance component if you were wise. In the event that A dies, whatever the cottage is worth, there would be enough insurance to buy them out, and then your family gets their interest, financial, from the cottage, and you are kind of satisfied that at least your 2 friends now take over the cottage and life goes on, and then they look after the very same thing. These shared ownership situations can be very dangerous, especially when there's mortgages involved. There was a term I came across many years ago called severally and jointly. In the event of a lawsuit against, say, A, several and joint means whoever is liquid pays. So that may put B and C at risk over mismanagement on the part of A, because did they take their share of the cottage and put it up as collateral for a further loan? So again, you can see the complications that can kind of come up. So just to repeat, per capita means 1, 2, and 3, 1 dies, their ownership goes to 2 and 3. Per stirps means if 1 dies, then their ownership passes to 1's family, so it stays on their side. So per capita is the same as joint tenants, and I saw that term somewhere along in here. I don't remember where it was, but I know we've covered it. Per stirps is the same as tenants in common, and so it's going to stay on that side of the family. I want to make sure I got that right, because I'm trying to limit my time on doing this. Per capita means 1, 2, and 3. 1 dies, the ownership goes to 2 and 3. Per stirps means it'll stay on your side of the family.